There was a request to go on the record. Okay. We're going to go back on the record. During the break, Mr. Lapidus asked to get the record. What did you want to put on the record?
Yes, Your Honor.
In your mic.
Your Honor, during the direct examination of the previous pharmacist, the state did exactly what we asked the court to preclude them from doing regarding the result of a pharmacy board hearing. In their motions that they filed, they stated that they sought to introduce this evidence as anticipatory impeachment to get ahead of what they believe the defense would elicit from them on cross-examination. Instead, what just happened was they made it a point to end their direct examination of that pharmacist by first asking whether he was in fact terminated or not from the hospital, and then the next question immediately after that was whether his ability to be a pharmacist was removed from him by the pharmacy board.
You're talking about eliciting the testimony. Okay, I think I got you. Okay.
There is absolutely no other reason to have elicited that testimony but to have bolstered his testimony to the jury to suggest, well, he wasn't fired, the pharmacy board didn't take his rights to be a pharmacist away from him, so clearly what he's saying has some weight. That is per se improper bolstering. It does not go to his credibility in the sense of anticipatory impeachment. It is simply bolstering. It's what we sought to prevent this entire time. And the entire time we filed our motions, we stated we were never going to get into the results of any hearings to specifically avoid any circumstances such as that. And it played out exactly how we had suggested it would play out. That's what I wanted to put on the record and ask the court to advise the state to stick to what they put in their pleadings regarding if they want to get into anticipatory impeachment, the court has allowed them to do so explicitly because you found it relevant to credibility based upon their representations. What happened there clearly wasn't anticipatory impeachment because he didn't even have his privileges taken from him. It was bolstering.
Okay. Ms. Swanson?
Ms. Sawyer?
Ms. Sawyer, I'm sorry.
That is all right. Your Honor, in the course of the testimony, before we even got to that issue about the licensure board with Mr. Dresbach, he indicated he had been placed on administrative leave for 8 months with the hospital. He also indicated he'd spoken to a pharmacy board representative, which is exactly what Talon Schroyer had indicated. So then the logical question is, were you terminated from the hospital, and did you lose your license? The answer was no. So it was just to finish answering the question, Your Honor.
But he's alluding to that you guys had represented that you weren't going to do that behavior.
I believe your order indicated, since it does go to credibility, that we would be allowed to ask that question, Your Honor.
How is the non-action of a completely entire entity go to credibility?
Well, I think the fact that he was placed on administrative leave certainly goes to a credibility issue of was he ultimately terminated, and the fact that he was interviewed as part of a pharmacy board investigator, that also goes to credibility, and he needs to answer the end result.
It's still a specific act. We're not talking about a wrong, a 607. You're talking about a specific act.
Again, Your Honor, I think it just addresses the end question of did you lose your license? No.
Anything else?
Your Honor, if the court is inclined to allow similar testimony to be elicited, we'd ask that the court instruct the jury in regards to how to accept that testimony. Because otherwise, it's inescapable that a layperson hearing that from the state of Ohio being asked that to conclude their the testimony of direct examination is simply to say, hey, by the way, someone else didn't take your privileges because what you said was right or what you did was right. And that's the exact thing we sought to preclude when we filed those motions. And their representations to the court in their response to our motion was that their belief was that we would elicit that on cross-examination, and that they would do it in an anticipatory way to get ahead to essentially go to the credibility of their witnesses before we could attack it. And what we told the court is that we had no intention, whether they weren't put on, whether they had their privileges revoked or not, that we had no intention of ever wanting to introduce the end results of those hearings to the pharmacists, nurses, or anyone else. And now what played out was the exact scenario we sought to preclude.
Well, doesn't a curative instruction accent the issue?
It may very well, which is why I would ask the court, first and foremost, to instruct the state to not elicit any more testimony about the results of these hearings, whether it be for the pharmacists or the nurses. And if the court is inclined to not do so, in the future, we would ask for limiting instructions if the court's going to allow the state to bolster their witnesses' credibility this way.
Well, what we're going to do is, if we're going to get to those issues, if that's going to be brought up during the state's questioning, sidebar before the question comes out. I don't want it out of the barn until we can put a record on there, and then I'll give a rule. Okay?
Thank you, Your Honor.
I don't feel a curative instruction helps us here, because I'm accenting something that was just basically the end of the questioning. I don't want to put any false light that they should told not to consider it.
Again, Your Honor,
I mean, if you want to propose a potential thing, we'll talk, but, you know, for right now, if you're going to get into those issues, sidebar first.
And Your Honor, if I can, just for the record, to complete our part of the record, I believe when it was discussed in voir dire, we thought a supplemental response, so part of what we were addressing in that question was based upon that supplemental response and the fact that it was addressed in voir dire, Your Honor, just to make it for the record.
Okay.
I don't believe we have to say anything further, Your Honor. Your Honor's ruling is very clear. It doesn't reference any doors having been opened. Your ruling said it was relevant to credibility based off their representations, and they did the exact opposite of what they represented to the court. So I don't believe I need to say any more.
Okay. We've got a record then. Anything else?
Yes, Your Honor.
Yeah.
Thank you. I am going to call this state's witness. And I have the settlement agreement from the Board of Pharmacy to present at this time.
Wait, I'm sorry, you're being called the state's witness.
I'm calling the next state's witness.
Oh.
Okay? He's a pharmacist. He signed a settlement agreement. Settlement agreement is here. I'm tendering it. If you have an objection about me talking about it, now's the time to do it, because the judge has said that he doesn't want necessarily to have this happen in open court. So if you'd like to see the settlement agreement, and then we can talk about it.
Okay, let's take a couple of minutes then. David, go back and run a little interference for me. Because I still have one more issue to talk about.
Your Honor, tell me when you are ready, Sam. I'll address this. We would object to the notice of settlement agreements in connection with the investigation of Mount Carmel and William Husel, dated March 4th, 2020, marked as State's Exhibit 25, from being introduced. It really dovetails on the argument that we just raised in terms of bolstering, but the litigation itself is names Randy Miles, who will be the next witness. It also includes information as to which cases or complaints were dismissed against individuals, which goes back to this bolstering argument. And then it lists certain pharmacists that are included in the settlement. I think if the state wants to elicit testimony about a settlement and that Randy Miles signed a settlement, or that there was a settlement, we certainly would not object to, was there a settlement? Yes. What was the amount? Did you sign the settlement? Yes, I did. No objection to that 3 questions, but to introduce the settlement itself, we certainly have an objection to that.
I don't think it goes back to the jury. I mean, she can allude to it, but I agree, are those 3 questions acceptable for your purpose?
There may be some more, but they would all be in that neighborhood. I'm not going to get into the allegations. I would only elicit what the actual agreement was, which involved a fine and some remedial action. We can allow
So you
the
had to
court
do
to
like
look at it.
seminars or something?
Your Honor, I'm
Had to do
sorry.
like seminars, continuing ed or something, or?
It had to do, well, Diane has the document, so thank you. There's a recital of terms. I can approach do we want to approach with the court reporter? And
For the record, this is State's Exhibit
it's 25.
5.
I'm happy to accept whatever direction he wants to take.
Well, oh, there's more, hold on.
There's a recitation of allegations, which I was never going to
Well, 2, we shouldn't get into the everybody denies everything and the
Yeah,
usual
yeah. It's an
release
agreed
document.
settlement entry without an admission of anything. If I'm allowed to lead, I can lead right through and ask for yes or no answers, and that way we avoid any extemporaneous.
I assume outside of 2, does any of this really matter to you?
Well, I guess then it becomes a relevant issue, but can I read that?
Yeah.
You can have it while I do the rest of the examination.
Well, no, let's just finish, let's
Okay.
resolve it now.
2 is your usual release. Denial. The other are, I don't like going into a bunch of sanctions. I said I don't like going into a bunch of sanctions.
Okay, so you would intend to say the terms of the agreement are beginning with 3, 4, 5? I'm not sure about, okay. Why don't we just do the perfect? I think that's much cleaner and what is,
Those are good questions that you asked.
yeah,
So we'll do the stipulation on the record at the appropriate time and then
Yeah.
supplement it with a written formal stipulation?
Yes, that'd be appropriate. We won't even have to we won't even have to ask the witness about it.
Right.
Okay.
And, yeah, I think that's perfect.
Okay, the third issue, and this is one, Ms. Schaefer was approached, one of the jurors went over to the other jury room to get something out of the refrigerator, I believe, and they were in there speculating about you all's tactics and the way you're approaching the case. When I heard this, I was going to direct them, you're not to discuss the case, the tactics, or anything. Okay? But I thought it was important enough for you guys to know that that was going on. I think I can cure it with instructing them not to discuss the case at all. But they were, I guess, trying to analyze you all's tactics. Any commentary?
Yes, Judge, I think the proper thing to do would be to bring the individuals in one at a time and make proper inquiries as to exactly what was discussed, what was said, and whether they fully understood the court's orders not to discuss this case prior to the case being turned over for deliberations.
I have a real problem doing it in open court. There are jurors, there are anonymities there, and it's being streamed.
I agree.
We can do it in camera with lead counsel if you wish,
I think that's probably the way to go.
and the court reporter and me. Okay? But I don't have the details as to who was what. I don't know which jurors to pull out. I know which jury room it was, and maybe we there, but I don't know if they switched back or forth or anything. So we may have to question all 18.
We would have an objection. Well, I was going to say the first thing that might, if both sides agree, that maybe David could inquire who went in this room during the break, and then break it down from there.
Did Darcy talk to you all about this?
No, this is the first time I'm hearing about it.
We defer to the court, Your Honor. I think some inquiry is appropriate. If you can narrow it down, that would be helpful.
Okay.
We don't want to spend another 2 days talking to everyone if we don't have to.
Neither do I, but as the court knows.
David, they
it's not
pretty
a
much been
violation.
staying in the jury rooms?
Yes, since I have been here and since I left this morning, obviously I was gone for 9
Well, I've got an idea which one it was in this jury room that went over there.
I don't know anything.
Well, I passed Darcy talking with her when I was coming from the restroom.
Okay, should I reach out to Darcy?
Yeah,
Okay.
Judge, is there a way we could just do like a group admonishment right now and just plow through this afternoon, because we've got people out in the hall, and then we can deal with it at the end of the day maybe?
We would object to plowing. I think what we need to do is take this matter very seriously, and it should be, I guess we should start with the juror that raised the issue. Maybe he or she could identify who it was, and eliminates us. Basically, takes a lot of time out of this whole thing.
I've reached out to her, Judge.
okay. Did she say who?
No, just sent it, because she was asking me a question regarding jazz upstairs, and I just sent this, so.
Okay. We're on pause for a second. Let's call her.
That could save a lot of.
Yeah. Got it.
Permission to go talk to the witness, Your Honor.
Yeah.
I'm just gonna go grab it.
Can you get Darcy on the horn for me?
She was getting ready to do a plea criminal for me. That's we were wearing two different hats.
Okay,
She
well,
said she's coming down. She got him started, she's coming down because Judge King's going to plea that was lined up.
she'll probably have to come through that door. Freight elevator's down. It's back up? Okay, come on right here. I thought you said, and she said that it might be different, yeah. That a juror approached you and they were talking strategies of the lawyers in the other room. Did I misunderstand?
You misunderstood.
What exactly were you told by the juror?
Strategies of the lawyer. There were two things that you and I discussed. The first was a juror approached me this morning about the notoriety of some defense counsel and how that had been discussed. She just said, and I do know specifically who that is. She said that, it did not impact her one way or another, but because of the admonitions, she felt compelled to tell me that there was a recognition about defense counsel and prior representation of defense counsel's clients. That was it.
Okay.
The other thing that you and I talked about was there were several jurors that just asked me if it's appropriate or they have the ability to preliminarily discuss how to handle some logistics. Not anything related to this specific case. They said nothing had been discussed. They wanted to know if it's possible for them to preemptively say, hey, if we have a dispute about this particular thing, this is how we want to resolve this dispute. Not saying that there was a dispute or anything like that, or that there were any discussions. They're just talking, is it appropriate for us to talk about logistics? I explained to them, the judge would give them all the information that they need, that my gut was they should not be discussing that, and we should not be discussing that until the judge has had the opportunity to talk with them.
Okay, well, I'm sorry I misunderstood you.
That's okay. No, I'm
It's
glad
not
you
like I
asked.
wasn't busy this morning.
I'm glad you asked.
Okay? Position now? Do you want us to come in and ask them about your notoriety?
Can we approach?
Yeah.
Do you need,
No.
he's got it.
Go.
If you guys have anything right now.
You guys can talk out there. That way it doesn't carry over. Okay. Work. Otherwise, nothing's gonna happen for, I'm guessing, half an hour.
Thank you.
Did you figure out which one you wanted to find?
I don't know, I thought it was anything from that.
Well, where's Darcy? Yeah.
I think, well, I guess. This wasn't something
I have no idea. I've been trying to remain anonymous as possible with it. I thought Darcy said they were talking. What's up?
Stream went down, so I'm gonna start back up again.
Well, we're kind of like in limbo for like 30 minutes due to an issue. So, there's going to be nothing to stream for the next 30 minutes.
Okay, so wait till then to come back.
Yeah.
Okay.
Okay.
Or suggested, I should say.
As long as you've explained to him his role in there and tolerance levels. We're off now.